Number 16, Alfred E. Butler versus the State of Michigan. Mr. Robbins.
Yes, sir. May it please the court. In the early summer of 1954, Mr. Butler, the appellant in this case, sold a book to an adult police officer in Detroit, Michigan. For this, he was promptly arrested, prosecuted, and convicted under a statute which, from the very outset of the litigation to this very day in court, we have contended is an invasion of the freedom of press and of due process of law. After our conviction in the trial court, we sought leave to appeal to the Supreme Court of Michigan. And the prosecutor, in consenting to the appeal, certified to the court that in his opinion the statute needed clarification. But the Supreme Court of Michigan denied our application for leave to appeal, and we had no clarification. Now, before I start on the main argument of the case, I should like to just clear the atmosphere for a second to indicate what is not in this case. We fully recognize that this is not a case of prior restraint. We were convicted for selling a book. Second of all, we also recognize that a properly drawn statute forbidding and punishing the distribution of obscene literature, just as simply as that, would be certainly valid under the exercise of a state police power. In other words, if the statute said it is a crime to distribute obscene literature, we say that that would be valid under the state police power.
You mean couch in those words?
Pardon, sir?
You mean express just as you expressed it?
Well, frankly, it doesn't have to be verbatim repetition of my words, but the mere proscription against the sale or distribution of obscene literature, and not with a lot of other qualifying phrases after it, it does not, in my opinion, make it unconstitutional.
I'm to infer from that you would regard the word obscene, period, as satisfying the written case.
I would, sir.
All right.
Now, the statute that we have here is a far cry from that. But before I get to the statute, I should like to call the court's attention to the book itself. I have in my hand here a facsimile copy of people's...
Before you get into
Yes, sir.
saying what you're clearing out, does that also include whether or not the book as a whole...
I'm coming to that, Your Honor. That is a point. I'm taking the position that as far as statute, I come to that later, but I'm going to develop the point that a statute, a containing statute is not constitutional, that a book must be judged as a whole.
You have an assertion in your brief, as I understand it, that the court did not find the book as a whole obscene.
That is true, sir. I do say that in my brief.
And will you argue that question?
I will argue that question.
But that's a very different question from whether a statute simpliciter outlawing or making a crime itself could be suspended obscene book.
If it's just
the statute is sufficiently is not offending against the rule against free business.
That's right.
Correct. So that one doesn't have to look at any book, just the statute, you say. The statute itself is all right.
I say...
It's a different question.
We are on a different question. I have a different statute, and I'm not claiming that this is just an obscenity statute. Now, as far as the book is concerned, I have in my hand a facsimile copy of People's Exhibit 1, which is in the record of this case. This is a paperback book. It sells for 50 cents. I'm happy to note that the covers of this book do not exhibit any sexually stimulating material. The front cover is a serious parade of the sad and serious figures of the leading characters in the book. The back cover has got a comment about the book by the Saturday Review of Literature. The front page has got some more reviews of the book, fulsome in their praise. And on the whole, it would be very hard to view this book as an attractive nuisance for alluring children into, or anyone else for that matter, into any salacious reading. Now, I should like to point out that much was made, and much is presently made in my adversary's brief, of the method of distribution of this book, and they take a sort of separate rule for paper-bound books as against hardcover books. Now, the only sale in the record of this case was a sale to an adult police officer. There isn't a scintilla of evidence anywhere in this case that it was sold to any child or read by any child. Now, there was evidence that it was distributed nationally throughout the country without any stimulating promotion campaign, that it appears on open racks in stores, that these stores are drug stores, are 5 and 10 cent stores, are department stores, are cigar stores, are newsstands. And it also appeared that in some of these stores, school supplies may be sold. Now, from that little bit of kernel comes the whole thesis that this book must necessarily, therefore, have been channeled or could be channeled towards and intended for adolescent reading only. No, sir, this is a word-for-word, virtually word-for-word. There were a few punctuation changes of some sort. But other than that, it is practically the same book, and I'm coming to the original edition of this book. But there isn't anything in the record that even approximates the quantitative analysis of proof that this book was channeled towards or intended for distribution towards minors. Gosh knows that adults can go to 5 and 10 cent stores and drug stores for many more reasons than children. Now, it so happens that at the time of the trial of this case, the hardcover edition of this book was in the public library of Detroit. At the trial, the chief of the book selection committee of that library testified that in their opinion they thought this was good literature, that the public library ought to have it, but because there were certain passages in it which were sexually stimulating, they put it on what they called the restricted shelf. That meant that while it was listed for the home reading, that meant that adults could come to the library and ask for it and get it. There was no problem about that, but it was not on the open shelves where children might get it. Now, just take the position, of course, that if the library had a copy of the hardcover, which it paid $3 or $4 for, and it was wanted to replace it or get a new one, if they wanted to get the same book for 50 cents and save the library's money, and wanted this edition of the book, nobody would dare sell it to them. Now, the book itself, we've talked about the distribution and the format of this book. The book itself has been paraphrased in my brief. It has been elaborately commented upon on the record. But frankly, it's a story of the conflict within a man. It's the story of a man who's tasted worldly life and earthly pleasures, and as a student of musicology, comes to this Benedictine monastery in the countryside of France to study the Gregorian chant. He lives in the monastery, and then for the first time in his life, he feels a different spirit evolving about him. He feels a call to an inner peace and happiness. He starts to realize that his life hitherto, fleshly as it may have been, is not what he is ultimately content with, and he has this conflict developing in himself with how much of the world will he give up and how much peace and security are represented by the monastery. Ultimately, he is won through to sanctity, but not without some tempestuous problems en route. Now, of course, he reminisces from time to time as to his prior pleasures and dalliances, and of course, from time to time, he lapses away from the monastic life. Now, some of this language and some of the description, I admit, is of earthy nature. It is realistic writing. It is of the naturalistic vein. There is some discussion and treatment of sex situations. There is also the blunt and earthy idiom of the French countryside. But viewed as a whole, as I will argue later and say now, as it must be, these were in parts that were indigenous to the story and at least fairly reasonably connected with its plot. Now, at the trial, when our constitutional objections were overruled, we went ahead and defended this book on the merits. We, two eminent professors, one from the University of Pennsylvania and one from the University of Michigan, the very area where the prosecution was brought, testified that in their opinion this was a serious work, it was excellent writing, it was a highly ethically motivated novel, and that viewed as a whole and by its dominating themes, it was a good piece of literature. Would be hard to fathom under that testimony how our proof beyond a reasonable doubt could be established. But we have to look to the statute itself to find out exactly how we were convicted. The statute says that if the book contains language and description which is obscene, and I'm coming to the other points, just take it from obscene, it is a crime to distribute that book. Now, I don't have to labor the point to show that we certainly contained in isolated aspects certain language which, if not related to the whole, might be offensive. But if the statute in this case permits a conviction for the containing, and does not, in the realistic sense, consider that the book must be treated as a whole and by its dominant theme.
Why don't you go to the statute?
Pardon me, sir.
Why don't you take us to the statute?
The statute appears on page 5 of my brief, Your Honor.
But as I understood you, the defect here is in the statute. You start out by saying this is not an ordinary obscenity statute.
That's right, sir.
So your attack is on the statute.
My attack is on the statute, on its face, and...
Go to the statute and find out what it's for.
All right. Now, the statute is a rather lengthy one, as I've reprinted it in page 5 of my brief. I think a fair and accurate paraphrase of the statute is that it's a crime to sell a book or distribute a book which contains obscene and there is a moral, lewd, or lascivious language. My position is that would be virtually the same as obscene. Obscene language or descriptions tending to incite minors to violent or depraved or immoral acts manifestly tending to the corruption of the morals of youth. That's the part of the statute that we were involved with in this case, because we had no proof.
You're suggesting that it's a statute that if there were a period after period. If there been a period, you'd have no quarrel.
That's right.
Is that right?
Yes, sir.
All right. Not challenging anything. I'm trying to find out.
Does the statute say contain, or does it say is obscene?
No, containing, sir. Containing obscene, immoral, lewd, or lascivious language, or obscene, immoral, lewd, or lascivious language, or obscene, immoral, lewd, or lascivious prints, pictures, figures, or descriptions, then the qualifying phrase. Tending to incite minors.
Without the qualifying phrase, you concede the statute is good?
That's right. That is the position I took from the start.
You concede that's your view, I suppose.
Pardon me, sir. I didn't gather your point.
You concede that's your view.
That is my view. I can't decide what's constitutional, Your Honor. I understand.
You're going a long way, it looks like, in connection with some of the cases.
Well, I understand.
Written in this field.
I understand. Well, when I say conceding, I don't mean any assumption of the authority of the court. I would say, perhaps may I modify to say that I would not be here contending that a statute which merely says it is a crime to distribute obscene literature is unconstitutional.
You mean you undertake the case?
No, sir.
Well,
that has happened.
Does that mean that your contention in regard to containing is not...
That is only one of my contentions, sir. I haven't had...
You said just now that you would concede if you put a period after descriptions.
Oh, I beg your pardon. Mr. Justice Reed, you're quite right. I was in error. I will withdraw my answer to Judge Frankfurter. The containing aspect I still would find unconstitutional.
You think it has to be the entire book?
That is right. I didn't realize the significance of that, and if they took the containing out and then put the period then I would be content with the statute. Thank you for pointing that out. Now, we've alluded, there is a wealth of authority to the fact that a book must be viewed as a whole and by its dominant themes, and you can't take isolated passages out of their context. Actually, at the trial, before the trial started, a long list of excerpts of the so-called salacious parts was prepared by the prosecutor, shown to his defense witnesses. They were examined on that, and a great deal of attention by prosecutor and by court was spent on having them read the excerpts and give their opinions about it. The focus of the whole rebuttal by the people was on the excerpts. Ultimately, of course, I believe that was our undoing in the finding. And the judge, in his opinion, the trial judge, in his opinion, definitely stated that he finds the book contains language and description. Now, I want to point the court, in all candor, I want to point to the court's attention to a further comment that the court made, and the trial court made in its opinion. He says, I find that this book contains language and descriptions which is obscene and so forth, and goes on with the qualifying phrases. And he says, and what's more, when viewed as a whole, I don't think these passages were necessary to the development of the plot of the book or the conflict expressed. Now that, I shouldn't want anyone to think that is in any way a view of the book as a whole. He is saying he finds, and he says he's taking the statute as it is. He says he finds that it contained these things. And then he gives, as a matter of dicta, in all due fairness, an opinion that literally these other passages weren't necessary. He doesn't say bluntly, and apt words were at hand, he doesn't say bluntly that this makes the book obscene as a whole. He just says it wasn't necessary to put these passages in the book, but he doesn't find the book by its dominant themes and by viewed as a whole was obscene. He says that, in his opinion, it wasn't necessary to develop the conflict. Now,
I have difficulty in following you on that. And so I am holding that the defendant is guilty because he sold a book in the city of Detroit containing this language. And also because the court feels that even viewing the book as a whole is not necessary to the proper development of the theme of the book during conflict.
Yes, that is the language I'm referring to, Your Honor. I'm saying that is different than saying that I find that this makes the book as a whole obscene.
It may be different words, but so
well, I think
the man is guilty because he sold a book containing this language. All the language of the book, I suppose.
No, well, you have to look.
What is all the language that's been referred to? Whatever is referred to all through the opinion.
But he is repeating.
All the passages that were read. I don't suppose you read the whole book.
I read the whole book.
No.
Oh,
I mean,
the court?
To the court at the trial.
No, the book was submitted in evidence, and the court read the book.
Obviously, there are words in there that are not
common parlance.
Well, they're not common parlance, and also words that are not salacious or obscene. But he says containing this language. The book contains this language, and viewing the book as a whole, I find the defendant guilty.
If Your Honor, please, but he's really repeating. I mean, the emphasis on this opinion, I think, is on the containing. Because above there, he says, however, the court does have to find that it is in violation of this particular statute because the statute does say that it is sufficient to contain lewd, immoral, obscene, and lascivious language or description. Now, his primary finding, if Your Honor, please, and I have no better way of delving into a judge's mind than anyone else, but I think if you look at the conduct of the trial and look at the examination of the witnesses and then look at this opinion as a whole, you'll say he's arguing all the time that it contains these things, and then he, for some reason, and I don't think this was justified under the statute, he's saying, and his questions to the witnesses at the trial were the same way, he's saying, didn't have to put this language in to get your point across, Mr. Author. And that's what he's saying here. He's saying it was unnecessary. That, if Your Honor, please, is more, not a legal judgment of what is obscene language and description, that is more a legal judgment of whether it was literarily or artistically necessary.
We're talking right here about the problem of whether or not he determined that the book as a whole was obscene.
Yes, and I say he didn't determine that the book as a whole was obscene. I say he determined...
Doesn't the first sentence in the first paragraph throw some light on what he was doing, where he says,
yes.
So that if therefore, if there ever is a review of my decision in this matter, I am not trying in any way to evade the issue. I'm trying to follow the statutes.
That's right, sir. I think he took the bull by the horns, and I think he was adding gratuitously. He was telling the world he saw no need for putting this stuff in there. It didn't help the book any. But I think he meant very definitely, and if the whole opinion and the whole conduct of the trial is examined, he meant very definitely to hold clearly that this book contained. And that's what we were in court on, and that's what we were convicted on.
And he meant to give a definite interpretation to a statute that might possibly have been interpreted to mean it must be obscene as a whole, and he refused to so interpret it.
That's right.
Therefore, we have the state court interpreting it as being purely limited to this containing point.
I think that is true, sir. I think it is limited to a containing point. I think if he wanted to say, the only other way he could have done it if he really wanted to obviate my contention was to say, now, containing doesn't mean just isolated passages. I'm saying that it contains it to the extent that the book as a whole is just replete with it.
And in order
now, he doesn't say that. There were apt words at hand, and he doesn't use them.
And in order to secure the constitutionality of the statute, it's conceivable that he might have so interpreted it.
He might have.
He didn't.
He might have, and he didn't. He interpreted, he convicted us because our book contained. And I think that's a fair analysis of the whole trial and of the opinion.
Does that mean, Mr. Robbins, that in a book containing 570-odd pages, under the construction given by the state court of the statute, and the statute comes here as though that construction were written into it, if a book of 570 pages, if the prosecutor in Michigan, to deal with the Mr. General, I understand about it. As I understand it, if you have a book of 575 pages, the prosecutor can say there are 3 pages that are obscene and tend to do these things, and he can rest, and he makes out his case. Is that right?
I think a very literal interpretation of that statute would justify that.
The statute plus the construction.
That's right.
Pretending and writing.
Yes.
That it comes here with an authoritative construction.
That's right.
And therefore, if he just culls out of this or any other book, 570 pages.
It is partly.
3 pages, never mind what the context of those 3 pages and the hundreds of pages before or after may do to those 3 pages.
This construction of the statute
Your position is a statute which does that.
offends freedom of press.
And the 14th Amendment.
Offends the 14th
Take it
Amendment.
down to that?
Does this case get down to it?
Yes.
The principles of this case get down to it. I mean, I don't think that he just took a few, just 1 or 2 little words.
No, I didn't mean that.
No, the principles of this case go down to that. It can't.
The interpretation of what is conceived to be the law of this case.
That's right.
The attitude, but the basis on which adjudication was made in this case is covered by the hypothetical simplification.
That is true,
Is that
sir.
right?
That is true. I would say that is possible, a very possible thing that we would have to fear if this was the construction. Now, this isn't we've spent some time on it, but it isn't our major.
Also say the other
I beg your pardon.
Boston too, I suppose.
I didn't get your
You
point.
also say that the other construction would be possible that he did say, as a whole.
I don't
No,
accede
you don't
to that.
say so, but I suppose it's a possible construction. You say
Well,
that
it's
the
not
other
for me to
construction-
say that it is possible when I have argued consistently that I didn't think that's what he meant, but I suppose reasonable men could differ on it. I'm not a Michigan attorney, Your Honor, and I really can't answer that authoritatively. I think any judge in any court, when a question of constitutionality is raised, would be obliged to follow the Constitution and his understanding of the statute and the Constitution and come to the best decision under the law that he could. I don't think there's a statute that says judges must decide against constitutional issues or must uphold statutes. I would think that he had power to discard this statute and claim it was unconstitutional, but I cannot answer that authoritatively. Well, I tried this case, Your Honor. The Recorder's Court is a inferior court to try mainly misdemeanors. It doesn't have a stenographer unless you ask for one. Its jurisdiction, I beg your pardon, my co-counsel has informed me, its jurisdiction applies to all crimes committed in the city of Detroit. Felonies as well?
It's the great criminal court of Detroit, isn't it?
Is the great criminal court of Detroit?
Yes.
I thought there was a county court.
Famous cases have been tried before.
I must apologize to any slight I gave to the recorded court. I was trying a charge there, which in this case, which I think was punishable only by a fine or small imprisonment. Now, our first and foremost constitutional objection in this case is not the aspect of containing, although we press that with great sincerity. I come again to the statute and say that what this statute also does is to say that if this book contains any languages and descriptions which is obscene for children, it can't be sold to anyone. In other words, if this is obscene and tends to incite minors, and thereby tends to incite minors to violent and depraved and immoral acts, manifestly tending to the corruption of the morals of youth, it cannot be sold. This means an adult couldn't buy it. This means the public library couldn't buy it, an educational institution couldn't buy it, and it means quite generally that the whole world of adult readership is fobbed off because it might be bad for children. Now, again, I don't want to labor that. I think it's a very drastic inroad on our freedom of press. In other words, what a child or an adolescent or a minor could not helpfully digest, or it might work some evil on him, that book cannot be read by or purchased by any adult. No one will sell that to an adult. Now, of course, we all know, as I said in the beginning, of course the police power of a state is quite right in protecting the adolescents and minors of a state, but there are limits to the degree to which they can go. They can't take overly drastic and highly excessive means to protect this situation. Once more, they reduce the whole adult readership in the community to the standard of a child's library. Actually, the statute itself I term a legislative codification of the rule in the Hickman case. The old 1868 rule in England was that a book was to be considered obscene if the matter had a tendency to debase or corrupt the minds or morals of anyone into whose hands it might fall. Therefore, it was the children and the village idiot and the moron that might be considered. Now, by the last 20 years, most of the courts in this country have abandoned the implications of the Hickman rule. Not every single court, but most of them have abandoned the implications of the Hickman rule and taken a better position in saying that it's the average person's sex instincts which is to be the test. In other words, if the book is viewed as a whole and by its dominant themes is dirt for dirt's sake to the average person, or just stimulates the sexual appetite of all classes of the community, then it can be considered obscene.
If the statute was limited to sales of such books to minors, you'd have a different case.
Well, I've considered that, Your Honor. I certainly would have a different case. I would have a harder case. I don't know if I might still not be here. I don't know if I still might not be here, but I'd have a lot harder case. Actually, it's not like liquor and tobacco. There's no constitutional freedom to distribute liquor and tobacco, but there is a literature, and I
didn't say
don't know about
mine. Different.
That's right, Your Honor. It would be a different case. So that is our second great complaint about the statute. And our third complaint about the statute is one as to vagueness and uncertainty. We say that if you look at this statute and you see that obscene is modified by these clauses, that its obscene language contains obscene language and descriptions, comma, tending to incite minors to acts of violence, depravity, and immorality. Now, I suppose I don't want to attack the word violence. I guess I could come to some accepted definition of violence. But I certainly would have a lot of trouble finding a definition of what is depraved or what is immoral, which on terms which reasonable men might not vary.
Using those qualifications render the term obscene vague.
Yes.
They take away the concreteness of the term obscene.
That's right. Whatever concreteness we've had in the term of obscenity has been reduced and virtually eliminated by saying obscene in that they do these things. That's exactly the force and effect of these clauses. Now,
would you think that something that was obscene could conceivably not have a moral influence on you?
Oh yes, it could conceivably, but things that are depraved or what corrupt the morals of youth, I don't actually know what standard is covered by the morals of youth.
It would be very difficult if you didn't have the lewd and obscene and lascivious first.
That's true, but I don't believe that you can say obscene and then say in that it does these things and claim that you have a definite concept of obscenity in that case.
It adds nothing to the requirement of lewdness.
Well, it isn't just that it adds nothing to, it very definitely adds such a wide field that I don't exactly know what publications might be interdicted. Now, I say reasonable men can differ as to what depravity and what immorality are and what manifestly tends to corrupt. And there's another aspect of this thing. It's tending. It even adds to the confusion by saying what tends to do these things or what manifestly tends. It even broadens and widens the entire field of interdicted literature. Now, there are no standards set up in the statute as to what tends to incite or what manifestly corrupts these youths. There are no standards in the statute. The judge doesn't give any standards. It doesn't show in any way in which these standards might be operative. There are no previous cases in Michigan giving us any signpost. And all in all, I would say that no member of the public could conceivably understand. He wouldn't have enough notice to know what publications were interdicted.
So, Mr. Robbins, does that mean that, as you view the statute, it proscribes an obscenity, not ordinary obscenity, but some special kind of obscenity?
I said yes, it proscribes an obscenity which is defined in a way which is vague.
Well, might not this statute also be read as merely proscribing obscenity as ordinarily understood, but having certain effects?
A state court could construe a statute, I suppose, any way it chose to. But we went to trial on the statute as it is now, with all this verbiage in it. Our witnesses were questioned. Our witnesses and the other side's witnesses were questioned, and there are examples of this in my brief as to whether something didn't tend to incite minors to violent and depraved conduct. The court, in its opinion, said that he thought this was obscene, lewd, and intended to incite minors to violent, depraved, and immoral acts. So that all through this case, we've gone on this litigation with the fact that it was established to the trial court satisfaction that it was obscene in that it tended to deprave.
Well, is there any evidence to the question directly whether this particular obscenity did have the effect of tending to incite and so forth?
This particular obscenity?
Involved in this book, in the excerpts.
Oh, no. The witnesses were directed to certain excerpts of the book, which viewed by themselves, they paid a good deal of attention. Actually, there was no expert testimony as to what motivated youths. None whatsoever. There was no expert testimony on either side as to what written words, if any, in here would tend to incite as experts. There were literary experts who at times thought that this material tended to deprave, to incite minors, but there was no expert testimony on motivation of any sort. Now, at the trial, we were confronted by these words. We didn't have a trial court that said, let's just forget about all these other words. Just let's say we're talking about obscenity, and that all this really doesn't interfere with the question of obscenity. If that was the case, the state court would have been a construction by a state court that this was just merely, as Judge Frank would have said, we put the period after obscenity. But we went all through the trial, and we've gone all the way up here, and we've got an opinion by a trial court which included these words. And we've had questions after questions to witnesses on that.
And you say that those qualifying words dilute the otherwise clear meaning of obscenity to the point of vagueness, making it unfair in the due process clause.
I would say that, except that I think, Your Honor, you say the otherwise clear. I'm not so absolutely positive that obscenity is completely free from any doubt, but at least It is
Constitutionally
sufficiently clear of doubt.
What does it mean?
Well, I have a great wealth of authority of varying shades. I can give you only my personal opinion that it means dirt for dirt's sake. That would be my best definition. There are.
That's a very
Pardon me,
clear,
sir?
That's a clear, constitutionally clear description. Dirt for dirt's sake.
I don't know how constitutionally clear it is, but it's the best I've ever been able to arrive at.
You think it's more vague than the state of trade?
Why do you think it's more
I don't
vague
really
than
know.
immoral?
Pardon me, sir?
Why do you think it's more vague than immoral by the phrase? Less vague.
Well, I am acquainted with the opinions that advert to long usage. I'm acquainted with that aspect of it. I think that is an important aspect of it. I think also because people deal with earthy things. Obscene literature and dirty books has been in everybody's mind for quite some time, and over the years of experience with sex and with literature and with dirty things, one gets some sort of common accepted feeling as to what is vague, what is generally permissible and what is not generally permissible. Human experience is probably the best answer to that.
In other words, the answer may satisfy the constitutional requirement, even though you may not be able to give an algebraic equation for it.
That's right,
You
sir.
trust the judgment of what's supposedly a good juror.
That's right, sir.
If that's true, why, on your argument, couldn't you trust the good jurors on immoral, lewd, or lascivious?
No more than I could trust the judgment. I couldn't trust the trial judge to charge a jury on that.
Well, you think you could trust them less to charge on that than you could on obscene?
Yes. I think I could trust the charge on obscene.
Maybe you could do that.
I suggest you say it hasn't been done.
It has been done, and
The other has been done too, hasn't it?
I don't know.
There are many statutes throughout the country that relate to what's immoral or not, and lewd and lascivious.
Yes, but there may be signposts, either in prior adjudications or in the statute or in the regulation.
And they have been sufficient in many cases for judges to charge them.
They may have been. My experience is not that broad, Your Honor. I concede that they may have been. My own experience is that, as far as literature is concerned, I have never been in a case where I was willing to let anybody charge as to what was immoral.
The federal language is lewd, obscene, and that's it.
Yes.
The old federal
With
statute-
lewd, obscene, and
lewd,
specific.
obscene, and
Now, this court, those words have been construed as Naki Sasokato ever since the Swearingen case way back in 161. Well, my argument has been eclipsed to this extent. I think I've said about everything that can be said in this field, except that on the last point, I want to call your court's attention. There are a series of motion picture cases. I know they're licensing cases. I know there are some distinctions because to some extent they involve prior restraint. But I think the tenor and the flavor of these decisions, and we haven't been blessed with many opinions here, but we've had a lot of decisions. The flavor of these decisions is such that would strike down words of such as immoral or what would debase and corrupt morals. It would strike down that as being overly vague and too indefinite. I say, of course, there's no difference between motion pictures and books, but I say that the same flavor of those decisions, despite incidental distinctions, ought to prevail in this case. Now, all in all, and I'll conclude my argument with this, all in all, if you want to really be realistic about freedom of press and due process of law, about certainty in criminal statutes affecting the distribution of literature, all in all, you are asked to construe here the prosecution of a book which we never were afraid to publish, and we weren't squeamish about it. It was by eminent professors have called it a great work. But we're convicted here of selling this book on a statute which really says it's a crime to distribute to anyone, a book containing language and descriptions obscenely motivating and corrupting minors or youth, and they're not interchangeable, under standards which are not ascertainable.
Before you sit down, I just want to ask you one question. Apropos of your remark, what I asked you the first remark a little while ago, you're familiar with cases that give respect weight to the fact that the statute is familiar. Oh, is that right? You said something.
Yeah. The statute is familiar or old?
But it has behind it age, the statute, right?
I don't recall saying that, but
Well, you got obscenity.
I said long usage in construction of obscenity, yeah. Long usage as to the construction of obscenity. Yes, I am familiar with that.
Now, that's what happened for me. It was. I noticed in taking Mr. Shepard's brief that this statute, long antedates the England case.
Mm-hmm.
Michigan evidently anticipated.
Yes.
Lord Coburn. And this goes back 100 years.
Yes, it does.
Say about that?
I can say that the modern period of enlightenment and considering obscenity is a young period, but nevertheless, if we're going to have freedom of press in the modern period, I really don't care how old the statute is. We've got a modern world to live in, and we've got modern considerations for the distribution of literature.
Admirable argument with regards to mothers, clubs, legislatures. Is it conclusive on a court? Doesn't the court have the last word on what it means modern?
I don't know. All I can say is the fact that the statute is even older than the Hickman case, if Your Honor, please.
I'm not saying that concludes the matter. I say it's very important.
It is important. I don't minimize it. I say when the chips are finally down, the question is how big an infringement of freedom of press have we got today?
If we had a scale on which we could weigh it, that would be easy. But this is all judgment on which age the longevity of the statute has, for one member of this court, to weight.
It does have a good deal of weight, but other things must have weight also. What's more, we didn't have paperback books when this statute was there. We didn't have ready public distribution to adults throughout the community.
Everything that's new is the greatest advantage to the
No, Your Honor. I understand that.
Mr. Shepard, Mr. General.
As I understand the word obscene, take it from the dictionary, it is that which is offensive to chastity of mind or of modesty, expressing to the mind or view something that delicacy, purity, and decency forbids to be exposed. And in my view, that word is not only well understood, it is somewhat elastic in its content, from age to age, and maybe in different localities. And my definition of obscenity would be that it is something which offends the conscience of the community, and that the final arbiter in determining whether a book is obscene is the jury. Now, in one of the jury of the community is the arbiter of the conscience of that community. Now, we have one case out of only three which have in any manner passed upon this statute, that is, the Supreme Court of Michigan passed upon. And that is People versus Lathers, 223 Michigan 92. In that case, a publisher of a newspaper was charged under this very law with publishing a story having double meaning. The judge, the trial judge, took the question from the jury and told them that without going to their jury room, they should render a verdict guilty. The Supreme Court of Michigan reversed that case, or that judgment, on the ground that the defendant was entitled to go to the jury on the question of obscenity. Now, I'm not going to dwell very long on this question of vagueness because I want to come to that word containing. I can't personally see anything vague or indefinite about this statute. I have condensed, leaving out a lot of extraneous matter, this rather lengthy section to read this way. as far as it is applicable to the facts in this case. Any person who shall sell any book containing obscene descriptions tending to incite minors to violent or depraved or immoral acts, and I insert the disjunctive there, or tending to the corruption of the morals of youth shall be guilty of a misdemeanor. Now, for the life of me, I can't see anything vague or indefinite in that language. Because the key word there is this word obscenity, as the dictionary defines it. And merely because you have phrases added to that doesn't deprive the person of his constitutional rights, because it's all hooked up to that key word.
Well, Mr. Shepherd, may I ask, is this statute the state's burden in establishing guilt of the misdemeanor satisfied by proof of some special kind of obscenity which is not ordinary obscenity, or is it that it requires a proof of some special effects of ordinary obscenity?
I do not apprehend that it requires proof in each particular case of some special effect on children or youths. I don't think that is true, not as I read it. I think that any obscene description, such as we find in this book, would tend to the corruption of the morals of youth.
Well, then, are you suggesting that the statute deals only with ordinary obscenity, and in actual
yes, sir.
fact that the appended language tending to incite, etc., is surplusage?
More or less, I would say, or descriptive.
Did the statute always have that provision in about youth, Mr. Shepherd?
The statute, as originally enacted, read this way: obscene descriptions tending to the corruption of the morals of youth. In 1954, this other clause or phrase was added: tending to incite minors to violent or depraved or immoral acts. That was added in the amendment in 1954.
Perhaps after lunch you could tell us why they made that amendment. Please.
Try to.
You may continue, Mr. Shepherd.
I would like, Mr. Chief Justice, to answer your last question.
Thank you.
And at the same time to re-answer a question from the Associate Justice Brennan. Now, Michigan has no record of legislative history. It'd be impossible to tell just why that amendment was enacted. My guess would be, and it's merely a guess or a suggestion, that additional phrase or clause was put in there because of the increase in juvenile delinquency, of which we are all aware. Now, if I might digress from the record, just to give you an illustration of that. The other day, just before I left Lansing, I had occasion to visit the state police post. And there, for the first time, I observed a polygraph test of a young man, 19 years of age, accused of statutory rape on a 13-year-old girl. And I watched that, and I observed his answers, and he didn't confess. I understand he did later. But the horrible part of it was that at the same time, 6 others were awaiting a similar test for statutory rape on the same 13-year-old girl. So it may be that facts of that kind induce the legislature to amend the statute. Now, coming back to my answer to your question, Mr. Justice Brennan.
Well, before you answer that one, Mr. Shepherd, I wondered if in passing this amendment, your legislature thought that perhaps it had to put another definition create another standard, let's say, or another type of obscenity in order to be able to convict people.
That might be true. That might be true. Now, logically, I pass to re-answering this other question. I do not think that under the statute that in each particular case you have to prove as a matter of fact that some particular youth or boy or minor was led to commit some act of deprivation. I think that the case, as a matter of fact, the issue of fact would be the matter contained in the book. Would the matter contained in the book tend to do these things? So that, as in this case, the recorder's court judge resolved the issue of fact by finding, as I view this record, that taking the book as a whole and having read it, it was obscene within this definition.
I understand from that it's the state's position that there was a finding on the book as a whole.
Yes, Your Honor. That is definitely. Now, at the expense of maybe of tediousness for a few minutes, I want to take you through this record and show you just why I make that contention. At the outset, a motion was filed on the face of the statute. The motion was filed to dismiss. And on page 16 of the record, there is some discussion about that in which the recorder's judge reserves his decision on that motion. And he didn't pass upon it until the end of the trial. Now, he says, among other things, in regard to that. Now, I would like first to meet with counsel because, after all, some of these passages are delicate. Some of these passages, I don't mind telling you, so far as I am only on page 123, referring to the book, and there are over 500 pages. And then he continues, I was pleased that the book was handed to me before the case commenced, which clearly indicates that at that time, when the motion was under consideration, he intended to read the whole book. Now, the court will turn to page 23. You will find that at that point in the case, during the receiving of testimony, these excerpts were introduced in evidence. And what the court said there clearly indicates that he did not intend to judge the book alone on those excerpts, because he says the court takes this position at this time. I have not read the complete book. I intend to. Now, whether I base my decision on the complete book afterwards or the excerpts contained in there will be a matter of my opinion, there. So he passes that by, and he introduces the excerpts solely for the purpose of identification. Not that he may judge them, but that they may, as he says, save a lot of time marking up the book and page references and so forth. Now on page 29, again he reserves the decision on the motion and clearly indicates that he is going to read this whole book, and he says that he's a slow reader, reads books very slowly, or your excerpts very slowly, or your briefs very slowly. I do not know that I have not completed reading anything but the brief and the motion. I have read part of the book, and I've read part of these excerpts. So he's progressing, maybe somewhat slowly. On page 32, we come to the point where they are about to introduce expert testimony on the literary value of the book and whether or not these rather violent passages which are under scrutiny here were essential to the theme. And he clearly indicates that is the purpose of admitting that testimony. Now, you turn to page 58, 59 of the record, again on expert testimony and showing just how the court's mind is working. down the bottom of the page, folio 84. Without objecting any further, my ruling would be the same on both issues. It would be of help to the court on the literary issue, and it will be of help to the court on the interpretation of the statute. I'm going to permit people who claim to know what it's all about to testify in this case. That will apply to both sides. Now, I want to point out just one thing here in passing. Judge Ricca admitted in evidence, or received in evidence, testimony adduced from experts on literary values, experts who had read this entire book and who testified whether these episodes were essential to the main object or theme. He would not permit testimony as to whether, in the opinion of any witness, the passages were obscene or the book was obscene, because, as he held right along, that would usurp his judicial function in passing on those questions. Now, at page 77.
To say he would not let the experts testify as to whether, in their opinion, the book itself was obscene.
Whether it was, yes, Your Honor. He would let them testify as to whether or not these passages were essential to the main theme of the book, this conflict between the spiritual and the physical.
Yes.
Now,
but he wouldn't let them testify even as to the obscenity of a particular passage?
No, Your Honor. He avoided that most carefully as I read this record.
Well, would he let them testify whether the excerpts would or would not corrupt?
No, I don't believe so. One or two questions may have slipped in and been answered, but take it by and large, he carefully excluded any expert testimony on the issue which he himself was to determine.
Well, the reason I ask that is I notice at page 32, he made the statement that I think they will be beneficial. Well, he said, on the other hand, I would like to hear the opinions. I think they will be beneficial and helpful to the court. The opinions both as to the literary value and as to whether or not it tends to corrupt morals. In fact, there was no such evidence.
He said that, yes, but I think, I can't point to pages, but his general approach or philosophy was that was a question, after all, for him to determine.
How did they qualify a person to be an expert in this field?
You mean as to literary value? There were a number of professors and book reviewers on each side who testified that for the defendant, the respondent testified that in their opinion it was a beautifully written book.
I understand that. What I was interested in, how would you qualify an expert in this field? What experience do you have to have different from that of other people?
Well, as
to be an expert in censorship.
Well, not in censorship.
But in determining whether books should be censored.
No, I don't think that was the point, Your Honor. I don't think that was the issue. I don't think that was the point on which they testified.
Well, what did they qualify? What was he an expert on?
He was an expert. They were experts on books and on literary values. And the gist of the testimony of witnesses for the defendant was this.
What were they, professors of literature or what?
Professors of literature in colleges and
anything else?
That they had reviewed different books and that sort of thing.
That all the experts were professors of literature?
Well, not all of them. We produced, for instance, Dr. Abler of the Theological College in New York. We produced
what theological college?
The Jewish Theological College in New York. The lady's president of it. And we had a bishop of an African church, and we had a father, a priest of the Catholic faith, who said they had read books, they had made the practice of criticism of books, and that they were versed in literary value.
Thank you. I just wanted to know
that, Your Honor, please, was the only issue of fact in this case as the testimony developed. Now, on page 77, it shows, I think, that the court was then studying this book very carefully. the bottom of the page. Now, just to clarify this, the conflict continues throughout the entire book. It's a conflict between the physical and the spiritual. And finally, the spiritual wins out. Is that it? He's questioning a witness here. It shows his interest. Yes, Your Honor. I'm trying to distinguish which? Between spiritual passion and sexual passion. The court, throughout the book, it starts and varies in degree as I get it, and then the spiritual wins out. Now, that's his quite evidently, he is taking a great interest in it and is reading the book. Now, I could refer to any number of page citations here, but I turn to page 171 of the transcript of record, in which the court says, however, the courts will permit, as I see it, the testimony as to whether the material contained in there is of such literary value as to justify these particular passages that might be immoral, lewd, lascivious, and obscene. So I'm going to ask you again, Rabbi, if you feel that some of the material in there is justified by the literary value of the book, can you answer that? So it shows that he's following through on that theory. It clearly indicates that he has read the book and is judging it in just that way. Here's another question which he propounds to a witness on page 179. I'm going to continue over on page 180, and I think I'm done. You think that the literary value of the book would have been impaired at all by removing or changing some of those parts in the book? That, well, particularly the vivid description of the, let's call it, sensual rather than sexual act. Do you think the literary value would have been destroyed if some of those were changed? Answer, according to my idea of the literary value, I'd say no.
What page is that on?
That's on page 179, Your Honor, please. Then on page 180, just a little short quotation down at the bottom. They've examined Father Villarreau. I'm right in that pronunciation. The court says, now wait, I've read the book. I would be terribly shocked if Father Villarreau had answered that any other way than he had. And again, on page 188, I hope I'm not too tedious, I think it's of the utmost importance. Another witness on the stand. The court says, on the matter of obscenity nor salacious literature, he has, as I said, received his qualifications, and it goes to the degree rather than the admissibility. So the court will ask you, do you think that the passages could be eliminated, so rephrased without affecting the literary value of the book? And the colloquy goes on between the court and the witness. Now, counsel has already gone over this opinion which the court read, and I think he followed. Maybe he followed both the Hickman rule and the modern rule, but at any rate, it's quite clear to me that he did, after reading this book, come to the conclusion that those passages, obscene passages, were not essential. They're overstressed, they're overemphasized, and that therefore the book as a whole was clearly obscene.
I wonder really whether what you've been through, Mr. Solicitor General, throws any real light on what the opinion means, because the threshold of all this, he specifically says that he's going to decide on one basis or the other, excerpts or the book as a whole, in his opinion. From where you began there on page 23, before he did, as he undoubtedly did, read the whole book, he says, now whether I base my decision on the complete book afterwards or the excerpts contained in there will be a matter for my opinion there. And you don't really get any light on anything until you reach the opinion, do you?
Well, and I rather doubt if you get a great deal of light on statutory construction by reading the opinion. I think that what the judge was doing here, the sole function which he performed, was to resolve the issue of fact. Are these particular passages obscene? Yes, they are. Now, if they're obscene, if you integrate them into the whole of the book, does that make the book obscene? Does the book contain obscene passages, applying the modern rule. That would be my view.
Mr. Shepherd, may I ask you this question?
Yes, sir.
There was an application for leave to appeal from
Yes,
the
sir.
Recorder's Court to your Supreme Court.
That's right.
To which appeal lies directly, as I understand.
Discretionary.
That petition by the defendant to secure a review from the Supreme Court was consented to by the people,
By the prosecutor.
by the prosecutor. The people agree, as I read their memorandum, that because the issues involved in this case are of great public interest, and because it appears that further clarification of the language of section so-and-so and amendment so-and-so is necessary, application for leave to appeal should be granted. Despite this consented application, your Supreme Court denied the application and did not read that the case called for further clarification. Now what I want to know from you is this. As I take it, our first inquiry is, what is the scope of the statute? What is the authoritative meaning of this statute, which we must take from your Supreme Court? What I want to know from you, that's the first one. What does the statute do? Because of attack on the patient. What I want to know from you, Shepherd, is to what decisions, other than what the recorder here taught, what decisions of your Supreme Court will you refer me to enable me to ascertain what I must take as the settled and controlling meaning of the statute, on the basis of which I must decide whether it does or doesn't offend the due process clause of the 14th Amendment?
That particular statute is under observation, to my knowledge.
Mr. Shepherd, would you mind talking closer to the microphone so
Yes, sir.
so all can hear?
Yes.
It's all right. You don't need to bother that. Just leave it.
The only case
Sorry to say that statute has been under observation.
Yes. Well, I mean, it has never been construed by our Supreme Court.
It has not.
Never. Except when they held in the Lathers case that a defendant was entitled to a jury trial.
Well, I should think that case is easy, because that simply says in the criminal case that the court can't
Yes, it don't. That's right.
So that I don't have to, from the point of laziness, a welcome answer, I don't have to read any Michigan Supreme Court opinions on this subject.
Not on this particular subject of obscenity, no, Your Honor. Statutes
weren't to find out what its scope is, except as applied in this case to what the recorder said. Is that it?
I don't think the recorder said an awful lot on how that language should be construed. He don't quote it. He simply decided the question of fact, as I view it.
Well, then is your answer to my question, and I put it in this egotistic personal way, because that's the way I have to reach the result. Is my job then to read this book? As yet I'm fully innocent of its contents. I then read this book and say to myself, well, they've held this is within the statute. Therefore, the statute covers a thing like this, and I must decide that a thing like this, if that's made a crime, whether that may or may not be made a crime by Michigan. Is that it? And I get no guidance from your Supreme Court opinion?
No guidance from our Supreme Court, Your Honor, please.
And I have to get it all out of my own head and my knowledge of reading English?
I'm sure.
Of what this is.
I'm sure you're capable of doing that, Your Honor.
Well, I know, but I can't make an individual judgment.
Wasn't it Mr. Justice Jackson who said that you do not sit as a super board of censors? Is that what you had in mind?
Well, that enable. Can I just quote that sentence in the statute?
Well, I think that these passages, or excerpts, if you want to call them that, are so foul and so filthy. Maybe it's my puritanical ancestors coming out here, or my very dear Victorian aunt who chided me once for referring to legs instead of limbs. But I think this
Go
thing...
beyond that. You would bad.
I hope so. I hope so.
What is your interpretation of containing? You were going to discuss that.
Well, I turn to a couple of cases, I believe from Ohio, Your Honor, please, that cited in my brother's brief. We had a situation, an ordinance or a statute provides, it reads, not wholly obscene, but containing certain descriptions. Not wholly obscene, but containing. Or you might have a law which says containing any obscene matter. You might have a different problem there.
And this doesn't go as far as that.
Oh, no. Any book which has salacious descriptions or obscene descriptions, and it certainly contains.
Well, you read the statute differently from what the other side reads.
I do, yes, Your Honor. Yes, Your Honor.
So we're not bound by what this court said because of the recorder's code?
Well, I have the utmost respect for the recorder's court. It's a court, it's a court of record. It has exclusive jurisdiction over all crimes committed within the city of Detroit. It has a court reporter and all that sort of thing.
That's the only expression we have from a Michigan court.
Pardon?
That's the only expression we have from a Michigan court on the exact issue.
Well, maybe I don't make myself clear. I think the only question that court decided was one of fact. And I think in deciding or resolving that issue, he used the modern rule. He may have decided that these excerpts were obscene descriptions. But I think he also held that integrating them or reintegrating them into the book, that the book itself was obscene.
And your interpretation of the statute then is that if he merely found that the particular passage was obscene, that doesn't violate the statute.
I don't understand that.
It's your interpretation of the statute, I take it, that if he merely found that the passage per se in of itself was obscene, that's not enough to violate the statute.
No, I think
that in context, the book as a whole.
Personally, I think that you should judge the book as a whole, or you run afoul.
We can read this statute that way, in spite of what this judge said.
That's the way I read it.
What you're saying is that like you the light on a virtual system, what you're saying is that we are to consider this as a simple, unqualified statute, making it in a sense itself obscene literature, period. And further, that there is to be incorporated the rule that in determining obscenity, the publication in its entirety as a whole, you can't tear out a page or two or a paragraph.
That's right.
That's your view. That's what...
I agree with Judge Hand on that. I do.
Well, I understand. That's a different statute. All I'm saying is that you're saying that's what the Michigan statute means, although the Michigan Supreme Court hasn't given us any authoritative light. Is that right?
That's right.
Well, why do you have to reach that at all? Did this judge decide on the book as a whole?
I think so, as I read this entire
record. If he did decide on it as a whole, you don't have to take up the problem.
You don't have to take up the marginal cases.
The marginal cases.
Marginal cases. There may be a case later on where...
It may be that one obscene word in a book would not ban the whole book under this statute.
That's right.
We don't reach that.
That's right.
What are the incidents that cover 40 pages in a 500-page book?
Pardon me?
What are the incidents that cover 40 pages on a 500-page book, and your recorder decides that the book as a whole is immoral, obscene, and so forth? What about that? Does that settle it?
I think that settles the issue of fact. Of course, they can go to a jury.
The incidents are only 5 pages. And he decides that it's bad as a whole.
Well, this is more than 5 pages. You're reaching a marginal case. We might run into trouble in a case of that kind. But
what about Shakespeare's Venus and Adonis? Where does it stand in Michigan?
The rape of Lucrece. I think if you put the rape of Lucrece in a in a paper-covered book and sold it through drugstore outlets, it might be considered salacious or obscene. Maybe.
And the man who had it, any bookseller who had it in his possession, would be guilty under your statute of violating that law.
If it were sold through those channels where children notoriously congregate?
We'll have to add one more element, Mr. Shepard, and a jury must so find it.
That's right. The conscience of the community speaking through the jury. Thank you for your attention.
Would it be proper to say that, I think has been said in some of the cases, that one must find that the dominant purpose of the writer was obscenity?
I think that's the basis of the whole book rule, is it not? Dominant purpose.
But the whole book might be obscene, but it might be a work of literature such as Innocent Adonis, which certainly it wasn't in a 5-cent copy or a 10-cent copy. It would probably hold obscene.
Maybe. It's quite a problem.
Mr. Robbins?
See.
Very well.